Hello, I'm Aaratrika Bhaumik and welcome to The Hindu. Can the Supreme Court, while answering a presidential reference, overrule its prior binding judgment? Well, that's one of the central questions before a constitution bench led by Chief Justice of India B.R. Gavai, which is currently hearing a reference issued by President Droupadi Murmu under Article 143 of the Constitution. But before we dive into this, here is some context. The reference traces back to the Supreme Court's landmark ruling on April 8th, wherein a bench of Justices J.B. Pardiwala and R. Mahadevan was dealing with a petition filed by the Tamil Nadu government. The state had basically challenged Governor R.N. Ravi's delays in granting assent to 10 bills that had been repassed by the state legislature and his subsequent decision to reserve them for presidential consideration. The court came down heavily on the governor's inaction, calling it unconstitutional. And for the very first time, the Supreme Court laid down judicially enforceable timelines for both governors as well as the president to act on state bills. Following this, President Murmu invoked the Supreme Court's advisory jurisdiction under Article 143 of the Constitution and referred 14 questions for the court's consideration. At the heart of these questions is a larger constitutional dilemma. Can the Supreme Court dictate how and when constitutional authorities like the President and governors must act, or would that amount to overstepping into the executive's domain? Further, two states, Tamil Nadu and Kerala, have filed separate applications before the Supreme Court, urging the court to reject the reference as a gambit by the centre to overrule a judgment already delivered. They have argued that the April 8th judgment has already settled the constitutional questions regarding the powers and the discretion of the President and the governors in granting, withholding or reserving assent to state bills. According to these two states, the union government is using the Article 143 route as a backdoor attempt to reopen and effectively overturn a verdict which it found unfavorable by bypassing the normal appellate process. So what does the Supreme Court's advisory jurisdiction actually entail? Well, under Article 143, sub-Article 1 of the Constitution, the President can ask the court's opinion on questions of law or fact that are not tied to any ongoing litigation. The provision traces back to Section 213 of the Government of India Act of 1935, which had conferred similar powers on the Federal Court of India. The prerequisites are clear. The President must be satisfied that such a question has arisen or is likely to arise, and that it is of such public importance that it warrants the court's opinion. Since independence, this power has been invoked at least 14 times. Importantly, the court is required to confine itself strictly to the questions referred. It cannot go beyond the scope of the reference. The Constituent Assembly debated this particular provision extensively. Some members feared that it could be misused for political purposes. Yet framers chose to retain it, recognizing its value in resolving constitutional deadlocks outside the usual course of litigation. However, to ensure that this power is not misused, the framers put in an essential safeguard, which is Article 145, subclause 3 of the Constitution, which states that any presidential reference must be heard by at least 5 judges. Can the Supreme Court decline to answer a presidential reference? This is also a very important question that has come up during such reference hearings. Well, it can. Although the Supreme Court in this particular case has chosen to entertain the current reference, Article 143 subclause 1 of the Constitution makes it clear that the court possesses the discretionary power to decline a reference. In the 1994 case of Dr. M. Ismail Faruqi versus Union of India, the Supreme Court has held that a reference may be declined if it involves questions requiring expert evidence or those of a purely political nature which the court is not competent to adjudicate. One of the most notable refusals actually came in 1993 when the court declined to answer a presidential reference on the Ayodhya Babri Masjid dispute. Justices A.M. Amedi and S.P. Bharucha cited the pendency of a civil suit on the same issue as grounds for refusing to respond. They had also held that the reference was unconstitutional as it violated the principles of secularism and expressed concern that the government might use the court's advisory opinion to further its own political agenda. Another important question that is one of the core issues again is whether the Supreme Court can overturn its April 8th ruling through this current reference. The short answer is no. In its opinion on the Cauvery Water Disputes Tribunal reference, the Supreme Court underscored that Article 143 cannot be used as a means for the executive to seek a review or reversal of its settled judicial decisions. The court's opinion underscored, and I quote, "When this court in its advisory jurisdiction pronounces its authoritative opinion on a question of law, it cannot be said that there is any doubt about the questions of law, or the same is res integra so as to require the President to know what the true position of law on the question is." The court further cautioned that a reference cannot be framed in a manner that effectively revisits a settled decision of the court. This essentially means that the Union government cannot use this particular reference to undo the April 8th judgment. Its only proper recourse would be to invoke the court's review or curative jurisdiction. However, the Supreme Court has also acknowledged that its advisory jurisdiction can allow for a degree of flexibility. In its Natural Resources Allocation reference of 2012, it held that while past judgments do remain final, Article 143 does allow the court to clarify, restate, or even elaborate upon legal principles so long as the ratio of an earlier judgment remains intact and the rights of parties in the original case are unaffected. The reference sought by then President Pratibha Patil after the 2G spectrum verdict allowed the court to refine its views on spectrum allocation without overturning the earlier judgment altogether. Similarly, in 1998, a presidential reference was used to refine the court's earlier ruling on judicial appointments. While reaffirming the validity of the current collegiate system, which was established in the 1993 case, Supreme Court Advocates on Record Association versus Union of India, the Supreme Court revised the composition and functioning of the collegium, thereby refining the appointment process without overturning the earlier judgment. Therefore, while the April 8th judgment is final and binding, its findings on the law may still be refined or elaborated upon by the current Constitution bench hearing the present reference. Further, the reference contains 14 questions of law which mostly stem from the April 8th ruling. However, they are not limited to it. Notably, the final 3 questions raise broader issues concerning the scope and exercise of the Supreme Court's advisory jurisdiction itself under the Constitution. Thank you for watching. For more such videos, please subscribe to The Hindu's YouTube channel. If you have any queries or feedback whatsoever, please write to us at videos@thehindu.co.in. Thank you.